I was going to say a few words introducing this panel, but since we're already behind time, I'm going to leave that to Ian, and that'll cut into his time today. Ian is a Professor of Information and Communications Law and Head of the Institute of Computer and Communications Law in the Centre of Commercial Law Studies, Queen Mary University of London, and has the longest title, I think, of anyone here. Ian will be giving a keynote on the long arm of law enforcement, and then we have an excellent panel to talk about some of the hot topics on the issue of transnational access to data from Internet intermediaries. Jan Kerkhoffs is a federal magistrate at the Belgian Federal Prosecutor's Office in Brussels in the unit dealing with cybercrime and terrorism. Jan is sitting immediately next to Ian. Mark Lang is Director of EU Institutional Relations at Microsoft. And Mark will be talking about the now infamous Microsoft warrants case that's currently before the US Second Circuit Court of Appeal. Caroline Wilson-Palot is General Counsel for Privacy International, and Caroline will be talking about in-lab reform and human rights challenges therein. And finally, Joanna Cavan is Head of the Interception of Communications Commissioner's Office, and she will be talking about some of the oversight challenges in this domain. But first I'm going to hand over to Ian, who will provide a keynote address for this session.
Thank you very much. Your microphone. Thank you very much, and good afternoon. I've been asked to I'm the warm-up act, really, in fact. Most of the way through my presentation, I have to say I can't say anything more because we have a distinguished panel of speakers who are going to speak about those particular topics. So, what am I going to speak about? Well, I'm going to speak about this issue of transnational access to data in the course of criminal investigations. So that's what I mean by this concept of the long arm of law enforcement, is because, and here I use cybercrime, but really any of the topics that we've discussed or are going to discuss in this conference could be supplanted in that particular bullet, because essentially we're talking about inherently transnational activities, whether the perpetrator or the victim or the computers or the networks or the evidence are in different jurisdictions has now become the norm rather than the exception. And the example I give here is the Yahoo, well, not the Yahoo case, another Yahoo case, which involved a terrorist attack or attempted terrorist attack against airliners, transatlantic airliners. The perpetrators were in the United Kingdom, the airlines were located in the United Kingdom, but a key piece of evidence, and a piece of evidence that actually undermined the first trial, was evidence held by Yahoo in California. So it's inherently transnational. In addition to that, this topic raises questions about material and procedural jurisdiction. What we have seen over the years is an extension of both material and procedural jurisdiction, which has given rise to a problem of concurrency, which Micheál is much better placed to talk about, having done an excellent PhD on the topic in your bookshops soon. Possibly. But the issue is essentially, as nation states extend their jurisdiction to encompass not only where the computer is, but where the perpetrator is, where the computer is, where the victim is, or even simply on the basis of an extraterritorial principle such as the active nationality principle, states are extending their jurisdiction. And that has benefits, clearly, that's partly why they're doing it, but it also has problems in its own right. And although that's not what I'm going to focus on today, I think it is important to recognise the context in which we deal with this issue of the long arm of law enforcement, because that long arm is crossing boundaries. And in terms of procedural jurisdiction, that creates some unique issues. So what I'm primarily interested in is this idea of moving evidence, on the basis that these criminal acts are inherently transnational, on the basis that the forensic material that will form the basis of an investigation and hopefully eventually a prosecution, then that evidence may have to transfer from one jurisdiction to another. And it's the complexities and the legal governance of that movement of evidence from one jurisdiction to another, which is at the heart of what I want to talk about today. Because I want to look at the range, and this burgeoning range of different ways in which evidence is moved, from formality to informality, from cooperation between states to unmediated access, direct access by law enforcement, to mediated access through the service provider. And that last category really is what ties, hopefully ties, this presentation into the theme of the conference. It's that enrolling of the internet intermediary. The internet intermediary as a service provider, as a person, or as a person that provides either communication services or hosting services, some of the topics we talked about this morning, as that intermediary, they are a tremendous forensic source. Not surprisingly, law enforcement have their eyes on that tremendous forensic source, and part of this issue about the long arm of law enforcement is about the ability of law enforcement to get access to that forensic material generated by service providers in the course of providing a service, as well as data held on their service in the course of hosting or associated services. And in that respect, I want to distinguish between mandatory and voluntary procedures. And again, this is a highly controversial component of the debate in terms of transnational access. Is to what extent are we enrolling internet intermediaries to voluntarily disclose the material that they may hold on us or about us, and to what extent they are mandated to provide that information. So that's the framework of what I want to talk about, and I want to do that by essentially going through a series of different means by which law enforcement get access to data, moving from this formality to this informality to this enrolment. At the most formal level, we have mutual legal assistance, and again, all of you I'm sure are familiar with it. We have the very traditional form of mutual legal assistance, the judicial request, the letters rogatory that took place, still take place today, between the courts, where a court will issue a request for evidence which is sent through diplomatic channels to arrive at the court of the jurisdiction in which the evidence may reside, and then, if you're still alive, the evidence will slowly make its way back to the requesting court. That mechanism still exists, but has over recent years been overtaken by interstate treaties, public law instruments, mutual legal assistance agreements, both bilateral and multilateral. And the most famous or infamous of those is the Budapest Convention, the Cybercrime Convention 2001, which in Article 27 essentially says, if you're a signatory to this convention, you don't have a bilateral mutual legal assistance treaty in place with another party member, this convention will do. This is the default position. It provides this multilateral basis for the exchange of evidence between jurisdictions, not court to court, as with letters rogatory, but on the basis of the executive. And that's a key distinction between the first and the second, is this is a process which goes through government. The request may be made by a court, but it goes to a central authority in the requesting state. It goes from the requesting state's executive branch to the recipient state's executive branch, and then down to the local judicial environment in which it is handled. And of course, that classic instrument of public international law has been highly controversial because of the time and the resources devoted to it. In terms of time, it is considered to be an excessively slow process. It involves states. It involves courts. Put the two together, you have an inevitably slow process. The alleged inefficiencies of that process have given rise to calls for reform. The US tech industry in particular has been sending repeated letters to Congress supporting requests by the Department of Justice to increase funding to mutual legal assistance. The apocryphal story is, of course, in the US Northern District Courts of California, where I believe there are a few service providers of interest to law enforcement. There is apparently one court officer who handles mutual legal assistance requests. One. Slightly overworked. And therefore, the US tech industry has been asking for more staff, more investment by the US to try and enhance this traditional interstate process, which is thoroughly lawful, thoroughly formalistic, and perceived to be inherently inefficient. Although, interestingly, a report was just published a couple of months ago, produced by the Centre for European Policy Studies from Brussels, and they actually questioned this inefficiency. They took some of the data that comes from the US European mutual legal assistance requests under the US EU treaty and actually question whether the statistics uphold this oft-heard complaint that it's a slow, boring process. But what I think is true and is recognised, I think, most succinctly in the CPS guidance I quote here is whatever formal mutual legal assistance procedures exist between jurisdictions, in the CPS's view, it all matters about how much the countries like each other, and it all matters about the attitudes and the people and opinions of the people on the ground. So, formality underpinned by essential informality. The more times you've gone to conferences and got drunk with your fellow law enforcement officer, the more likely the mutual legal assistance. He knows that's right. The more likely the mutual legal assistance procedure is going wrong. I hope you could charge that alcohol against business expenses. But Europe has gone beyond. Well, it's gone beyond a lot of things. But it's gone beyond the mutual legal assistance, and with the coming into force of the Lisbon Treaty, we now adopted the mutual recognition principle that can underpin interstate communications. And due to time, I won't spend a long time on this, but I wanted to highlight in particular, of course, since 2014, we now have this European investigation order, which does not come into force until 2017, but is designed to go beyond traditional mutual legal assistance. It doesn't require the formality and time inherent under MLAT, and what it permits is this recognition of court procedures in requesting state A are simply complied with in jurisdiction B, where the request is received. It doesn't encompass all of the 28 member states. The UK opted in, but Ireland has yet to choose. And again, that's quite an important missing country, because again, there's a few service providers located somewhere around Dublin, I believe. But they're not part of the European investigation order. But what we're seeing, is this possibility of a greater degree of integration between states that facilitate the long arm of law enforcement. And in fact, the SEP report, the report that I mentioned a moment ago, actually calls for the European investigation order to be a model for future relationships between the US and the EU. The ability to facilitate through simplification, through mutual recognition, that our legal systems are the same. Question mark. Next, mutual assistance. Mutual assistance is a process of cooperation, police-to-police liaison. Not just the bar, although the bar is a very important situation in which to cooperate, but it's more about intelligence than evidence. It's about informal cooperation between foreign law enforcement agencies, and only yesterday, Wednesday the 16th of September, the US Attorney General was in Brussels at Europol, announcing that the US government has decided to place a US prosecutor in the European Cybercrime Centre to facilitate police-to-police liaison, to facilitate that mutual assistance between the two countries. What we see in the Cybercrime Convention is what is present in a number of other international instruments, this need for 24/7 networks. If police-to-police liaison is going to be effective, there has to be somebody to liaise with. And these 24/7 networks are a critical infrastructure that underpins effective exchange of information between law enforcement agencies. In addition to that, you have this concept under Article 26 of the Budapest Convention, spontaneous information. Always struck me as a lovely phrase, that spontaneous information being spontaneous. And of course, the ability to rely on proactive disclosures rather than requests becomes much easier in an environment where, because of this extension of territorial jurisdiction, a crime in your country is actually a crime in my country as well. Therefore, when I find out about a crime that's been committed in your country, I can spontaneously tell you about it. And that is another form of long-arm reach for law enforcement. So, if MLAT is the most formal, and mutual assistance is considerably more informal, the third category, or the second category really, is what I refer to as unmediated access. This is where law enforcement doesn't deal with another state, it doesn't deal with service providers, it engages directly with the material itself. And here we see various different mechanisms or grounds upon which this material is engaged with. We have the concept of accessibility. If I am law enforcement, I bust down the doors, I go in, I catch the perpetrator, fingers at the keyboard, but there's nothing on the machines in the premises, but I can see he is accessing a computer in a remote location. Then to what degree can those domestic search powers be used to get access to those remote systems? The Cybercrime Convention deals with it, but it deals with it on a domestic basis. If computer 1, where the search is taking place, is connected to computer 2, which is also in the United Kingdom, then law enforcement can extend their search to that which is accessible, that other system in the territory. But, of course, that domestic limitation is only applicable if you know where that remote computer is. And I certainly know within the Netherlands, the prosecutors have been advising their law enforcement not necessarily to know where those remote computers are. Why would you want to know where that remote computer is? If you know where that remote computer is, you may place jurisdictional limits on what you can do with that computer. However, not an acceptably legally process, but in other jurisdictions, and I give this example of New Zealand, they have specifically provided for the possibility of a remote access search. And I recommend, if you have a spare moment, to look at this legislation. It's great. It basically says, if you can find a resource and you can't find out where that resource is, you can seize all the material you want from that remote resource, but then you must send a note afterwards telling them. It's a bit, it's a bit like the burglar leaving a visiting card. But New Zealand law enforcement are obliged to do that. So that's one mechanism. Another mechanism of unmediated access is the publicly available, the open source. Article 32A of the Budapest Convention, regardless of where the data is located geographically, if it's publicly available, law enforcement can get at it. That, of course, doesn't mean that law enforcement are not regulated in those activities. Clearly, if law enforcement, if the local police force is regularly accessing my Facebook and monitoring my behaviour on my Facebook account, A, that's incredible because I don't have one. B, that would be a form of surveillance regulated under national legislation. So just because you can get to it as law enforcement doesn't mean it's not a regulated activity. Under UK law, and the Office of the Surveillance Commission has made this very clear, is systematic observation of publicly available material is surveillance. and therefore requires authorization as such. Third category I refer to as just passing by or through. What I mean here is the revelations from Snowden about satellite intercept, submarine cables, tempora, and the extent to which the US embassies abroad have been used as just picking up information that passes through. They've got equipment in the building that just picks up stuff. It's in the air. And of course what Snowden revealed was Section 8.4 of the Regulation of Investigatory Powers Act, this bulk access to external communications is actually a lot more important than we ever thought it was. And perhaps Joanne may want to say more about that in a moment. Last but not least, of course, the other form of unmediated access is the breaking into systems. And again, Snowden revealed the tailored access operations run by the National Security Agency, but it's on the face of UK legislation. The Intelligence Services Act, Section 7, authorises UK agents to interfere with the property of foreigners. The Computer Misuse Act, only this year, in April this year, was amended specifically to say law enforcement can hack your computer, can modify your systems, and are immune from prosecution. So, let's not be fooled, they break in. So, final area is that question of enrolment. And of course here I'm talking about the mediated access with the service providers. Service providers, we're lawyers. What do we mean by service providers? That really matters from a legal perspective, because if you are one category of service provider, you have certain obligations. If you are another category of service provider, you will have different obligations. Budapest takes a broad perspective. European law has examined this issue in detail. The Yahoo case is going to be discussed, so I don't need to say any more about that. But because of uncertainties under UK law about how big the bucket is when it comes to service providers and their obligations to assist law enforcement, the bucket was made bigger. So last year, through the Data Retention and Regulatory Investigatory Powers Act, the bucket of what constitutes a service provider was made bigger. So, very briefly, in terms of service provider, I think we have to distinguish between mandated access and voluntary access. In terms of mandated access, I would again distinguish between two approaches. With respect to domestic service providers, those that are actually here in our territory, the Cybercrime Convention, domestic law, talks about possession or control. If the service provider is in possession or control of somebody else's data, then they can be required to hand it over. That is the basis of the Microsoft case. Whether it be Microsoft, a US company based in the United States, or whether it be Deutsche Telekom based in the United States. If they are in the territory, this is what we're waiting to find out from the Federal Appeal Court, but if it's in the territory, they can be required to gain access to any data, wherever it is, that's in their possession or control. The long-arm reach of law enforcement. We don't know what the outcome of the Microsoft case will be, but that is at heart what the essence of what the case is about. It's about how, through those domestic service providers, long is the arm of law enforcement. The other side of that is, of course, for service providers that aren't in the territory but simply provide services into the territory. Essentially the problem of every other country except the United States. And here we have the Yahoo case, and I will not say any more about that, but again, because of concerns in the UK, in DRIPA 2014, the government made it very clear the extraterritorial nature of their right to ask those that provide services in the territory, we don't care where you are, you may not have any domestic infrastructure, but you are subject to our legislation. In terms of voluntary, this is a much more controversial area. We have voluntary provisions with respect to to retention under Anti-Terrorism, Crime and Security Act. We have voluntary disclosure provisions under data protection and other related legislation. And the most controversial area is, what does Article 32B of the Cybercrime Convention mean? It means you can obtain the lawful and voluntary consent of the person who has lawful authority to disclose the data. Well, that's clear. What it could mean, we believe, is because every single cloud provider, we as in you or we, me and my mates, well, what we believe it could mean is if you're a cloud service provider and every single cloud service provider says this in their standard terms and conditions, we reserve the right to disclose your data in response to a law enforcement request. We think service providers can rely on those terms and conditions, potentially, to disclose your data. That is controversial. The Cybercrime Committee, in its guidance in December 2014, said, we're not really sure. We don't think that's the case, but it could be the case. It depends. A very good depend. I mean, we're lawyers. We always say it depends. And the Council of Europe did that. So, your favourite slide. In conclusion, the long-arm reach of law enforcement. What we are seeing is concerns about exceeding powers in terms of both the application to whom these requests may be made, as long as to whom these requests may be made. We've seen over recent years a shift from formality and that towards greater informality. But what I think we're seeing now, and as a consequence of Snowden, is a move back towards formality. Snowden undermined, rightly so in my opinion, the culture of cooperation that built up over the years. And again, everybody has to say, well, let's reset everything again and think again about that culture. To what extent are we adequately protecting the rights of individuals? Of course, jurisdictions do have differential protections, and privacy is a key example of that between the US and the EU. We have issues of accountability. The problems that people such as Joanne has of getting access to the records of service providers in other countries, to be able to ensure that the proper accountability procedures have been followed. And last but not least, we have these questions of evidential consequence. If this becomes evidence in a court of law, then we have to demand of our tribunals, our courts, that they do exercise regulatory control, that they do ensure that data that is being reached from foreign jurisdictions is lawfully used in court in a fair and appropriate way. And with that, I've gone over, I'm sorry. Thank you.